Mayor, please call. I was just sort of about to go to the ICSID convention, because it's the convention and then the act which actually make good the whole of the jurisdiction argument.
Yes.
So the convention is in volume 1, behind the act, which is in tab 2, as my Lord Chancellor pointed out, page 28. If I may, I'm just going to go to the what we respectfully say are the relevant articles, but to start just with the preamble, which is on page 28. And the preamble begins with the contracting states considering the need for international cooperation for economic development and the role of private international investment therein, and then bearing in mind the possibility that from time to time disputes may arise in connection with such investment between contracting states and nationals of other contracting states, recognising that while such disputes would usually be subject to national legal process, international methods of settlement may be appropriate, attaching particular importance to the availability of facilities for international conciliation or arbitration to which the contracting states and nationals of other contracting states may submit such disputes if they so desire. And then the establishment of facilities is the next two paragraphs, the second of which is recognising that mutual consent by the parties to submit such disputes to conciliation or to arbitration through such facilities constitutes a binding agreement which requires, in particular, that due consideration be given to any recommendation of conciliators and that any arbitral award be complied with, declaring that no contracting state shall be a mere fact of ratification, acceptance or approval of this convention without its consent be deemed to be under any obligation to submit any particular dispute to conciliation or arbitration. So, pausing there, as we see in Schroer, what they set out to do, and in fact did in the convention, was put on the superstructure above such underlying bilateral investment treaties or multilateral treaties as in particular fields might be agreed between different sovereign states or above any contractual agreements which might use this convention. So they're not setting any fair and equitable treatment standards or anything like that. That's left below, and it's clear the binding intent is made out there, which we'll come to in a moment. Page 38, we've got a little bit of feedback.
Well, that penultimate recital in the preamble
is quite important.
The points really does indicate mutual agreement, mutual consent to compliance with any arbitration award.
Exactly. It's there right up front. So, but it's actually brought home by what we respectfully say is the obvious and sensible construction of a treaty, which is the key provisions in the context of the other relevantly related provisions. And if we go forward to page 38, which is in chapter 4 of the ICSID Convention, section 3, we get article 41, and 41.1 specifically provides that all the contracting states agree with each other that the tribunal should be the judge of its own competence. And that becomes important because that feeds into the ultimate validity of the award as we see it. So then we've got page 40. And we've got there section 5, which is interpretation, revision and annulment of the award. And obviously 50 deals with meaning and scope and potential stay for that termination. But the key one here is really 52, which is the annulment provision. And that's either party may request annulment, as they did in fact here, and it's, I don't think anyone's, it's completely obvious those grounds can include jurisdiction of the tribunal. They fall within the sub-paragraphs under 1. And then we then get section 6, which is our key section, which is recognition and enforcement of the award on page 41. And we've got Article 53, which is the binding force, and shall not be subject to any appeal or any other remedy except those provided for in this convention, which we say is obviously important, because it's going to be binding and have the force of res judicata if it were.
Well, that's the point, isn't it? You have the award. You've got Article 41. It's determine its own competence or jurisdiction,
and then it's binding.
Then you get the annulment provision, which is a complete remedy, the only remedy.
Exactly.
You've exhausted that remedy. There isn't any other.
That's it, and that's the scheme of the convention. So, and then you get the output of that, which, as we'll see, is it has to be an authentic award. But apart from that, that is the end of the inquiry, the formal inquiry. And it's then the second sentence. So it's the preclusion, firstly the provision in 53.1. It's got actually some specific components. First, the first phrase is binding on the parties. So that's Spain for these purposes, and of course my clients. And then shall not be subject to any appeal or any other remedy except those provided for in the convention, which is 52. Plus any clarification or rectification, but it's within the convention, and that's a particular feature of the convention. So that's the preclusive effect of all other remedies in the second limb of the first sentence of 53.1. And then each party shall abide by and comply with the terms of the award, subject to any stay. And you can get a stay if there's a 52 challenge, for example, but you can only get it from the ad hoc committee. And then obviously 53.2 just makes it clear that the award includes anything done under those provisions, perfectly obvious why. And then you get 54 and 54.1, each contracting state, so that's everyone, shall recognise an award rendered pursuant to this convention. And the registration of the award under the 96 Act is the domestic law process by which that recognition is given effect. So it's an absolutely obvious agreement. I, with respect, adopt the premise of my Lord Justice Phillips' question to my learned friend. I mean, it's perfectly plain what it says. But when you analyse it, it becomes even more plain, we would say. So that the first thing they're obliged to do is give recognition to the award in 54.1. It's a totally unqualified obligation as binding. And then the second limb is enforce the pecuniary obligations imposed by that award within its territories as if it were a final judgment of court of that state. Now, pausing there, that is the sentence that was lifted from the EU treaty, the original EEC treaty. So our submission is that post-1957, the EU treaty works, everyone can see it works. I think, well, that's quite a good way of doing it. And they come up with that wording, and that's what they agree. And there are some very important words, which I think my Lord the Chancellor has already alighted upon, but the words final judgment. Yeah. Because that's quite important in this. And the reason I say that is because all of the submissions made by, on that side of the court, by Zimbabwe and Spain, about how important sovereign immunity is, it's absolutely cardinal principle, it's a procedural bar to the exercise of jurisdiction on the substantive dispute, all of that's correct domestically. That's all, there's no real dispute about that on its own terms. But the short point is that in the Sultan of Johore's case, because of that, it was impossible for the, I think, well, there was a gentleman who nipped up a ladder into the ceiling
Is that
over lunch.
Well, that sounds as if it might be the. Is that you? Or?
No, I think they were trying to turn on a speaker there, and it's resulted in a.
I'm gonna have it off.
Sorry?
I don't think I can switch it off.
Might get a tiny bit wearing after a couple of hours, I think. But, I don't know
It's getting loud.
whether there's any.
Can you ring Robin Bolton?
I'm going to try and make another call.
If we just carry on for the moment and see if the. Okay, carry on.
I'm good.
Sorry.
I'll compete with the. But the short point is that in the Sultan of Johor case, the court would not even take jurisdiction. So the court was in no position to even begin the case, as Spain and Zimbabwe forcefully point out, less still to get to the position of a final judgment, which is not open to any normal remedy.
Yeah.
So the importance of the words final judgment are that they show that what was intended to land under Article 54 was something that sequentially post-dates any consideration of sovereign immunity, and that is only consistent, that premise is only consistent with a submission to jurisdiction, or given the EU origins, a conferral of jurisdiction by each state on the other, to enforce the law in that way.
It's inconsistent, you'd say, with any reliance on sovereign immunity.
Yes, completely impossible. You can't have a sovereign. The domestic court cannot get to a final judgment if there's a priori procedural bar to the exercise of any jurisdiction.
Yeah.
So even on the terms of Article 54 itself, I mean, the words are clear on their face when you first read them, and then the more you analyse them, the stronger their effect is.
But the process of recognising an award is only going to lead to a final judgment, isn't it? It's not going to lead to anything else.
My lord, that's right, but there's, unlike if you look at contrast with the New York Convention, that the process of recognition, if it happens, and subject to the bases of challenge in the New York Convention and the 96 Act, you've got a whole load of intervening steps there, one of which is want of jurisdiction.
That's the process of recognition.
Indeed. But the deliberate choice
Well, the
of
point
the...
you're making, just so I can understand this, because what it says is that it's to be recognised, and then it goes on about enforcement, just to look at recognition for the moment, recognised as if it were a final judgment of the court.
Yes.
And your point is, well, it can't be that exercise of recognition as if a final judgment is completely inconsistent with any reliance on sovereign immunity.
Indeed.
Because the effect of reliance on sovereign immunity would be that you never got to
Exactly.
adjudication, let alone
Exactly.
a final judgment.
Precisely, and my lord, the reason, just to answer, I think what lay behind my lord Justice Phillips' question is that's always true in recognition generally, but the point is this is a closed pipe to that result in Article 54, unusually. It's basically automatic recognition straight to a final judgment.
I understand. My difficulty with the argument is that if there was state immunity, you wouldn't recognise either at all. So I'm not sure why final judgment adds anything to that.
Well, but because, so,
I suppose it demonstrates that sovereign immunity has got nothing to do with this.
well, precisely. The question, what I was seeking to pick up is, I think, your lordship's question, which is, what were the parties actually agreeing to? What can we see the contracting states were agreeing to? And that is, it's a very closed agreement, which is completely plain, that it is not subject to any quibble about sovereign immunity. And that's the only, we respectfully say, the only natural reading of that provision. And that quality of finality is that it should not be open to any other domestic remedy. That's the only way it's consistent with the preclusive effect of the overall scheme, which I'll come to, and I'll show you in Schroyer where that's dealt with. So then, if I could just carry on and go through the provisions of Article 54. Federal Constitution is the second half of that Article 54, which we don't need to bother with. Then you've got 54.2. A party seeking recognition or enforcement in the territory of the contracting state shall furnish to a competent court or other authority, which such a state shall have designated for this purpose, a copy of the award certified by the Secretary-General. Each contracting state shall notify the Secretary-General designation of the competent authority for that purpose. So there are requirements domestically to have such a competent authority and to notify under the Convention. And all that is required here is the provision, the furnishing of an authentic award as the trigger for the scheme of these three articles. And we see that obviously in the 96 Act, which we'll get to in a minute. But in then we get Article 54.3, and all the points that were being made during my learned friend submissions about a long treaty and no one ever mentioned it. That is because it's the fundamental assumed premise of the treaty that these awards will be enforceable, to which there's an express qualification in relation to execution, which we find in 54.3 and 55. And it's impossible to read it any other way, sensibly. 54.3 is execution of the award shall be governed by the laws concerning the execution of judgments in force in the state in whose territories execution is sought. And then 55 was a point of clarification which speaks directly to, indeed expressly, to Article 54. Nothing in Article 54 shall be construed as derogating from the law in force in a contracting state relating to immunity of that state or of any foreign state from execution. And as my Lord said, sorry.
At the moment, it seems to have stopped. Is it to do with the speakers or is it to do with the heating?
I'm not sure. Someone came in at lunch and then
Because my
the film
clerk
was
said it
something.
was to do with the heating, but it doesn't seem to be appreciably cool. But don't worry.
Would you still
Lord
want
Justice
someone
Fraser is being brought in to sort this out.
That will be a rigorous exercise.
Well, no, I mean, joking apart, the Lady Chief Justice has asked Lord Justice Fraser to, as it were, take over and get to the parts that other judges like the Lady Chief and myself can't reach.
It certainly has a height.
Yeah, okay.
Good.
Sorry.
So, the point is just a simple one. They made absolutely express provision for no derogation for sovereign immunity on execution. And the only sensible
Well,
way,
it makes no sense at all, does it really?
well, why,
Unless the rest of it is dealing with
exactly, you
is, as
can't,
it were, kicking out sovereign immunity.
you can't read it any other way, we respect
And whether the judge's primary way of doing it was a little short point, which was that the Sovereign Immunity Act didn't really apply at all.
Well, I'll come to that, because it's,
Speaking for myself, have a certain amount of difficulty.
well, I was,
Section 2
seems more obvious.
is,
Yeah.
I mean, you would say that A40, all right, these provisions
Yes,
are a submission to the jurisdiction within Section 2.
absolutely. They are, I mean, possibly to be characterised rather like a conferral.
Yeah.
There's no difference to the purpose of the case, but that's what it was when it was done within the EU.
Yeah.
So that's the only way of reading that. And then it's quite important also for the court to have in mind that on page 45 we find Article 69. Because it's all very well for me to make my submissions on the law of sovereign immunity and say par in par and states can agree what they want. And true it is, but we do have to trace that through into domestic legislation to find the proper foundation for it in the statute.
Yeah.
And it's significant that Article 69 itself expressly placed the obligation on the contracting states to give effect to it by putting in place the legislative machinery. So it's a very unusual, it's an unusual set of provisions. It's not unique. It is unusual because what you have is you have the reach in from the international treaty directly into the domestic legislation, and you have, certainly in the United Kingdom, the reach back from the convention back into the domestic statute because it's actually appended to the Act. And I think analytically that doesn't necessarily make such a difference, but impressionistically it's pretty clear how that would have appeared to Parliament in legislating to that effect. So Article 69 on page 45 expressly provides each contracting state shall take such legislative or other measures as may be necessary for making provisions of this convention effective in its territories. So if the United Kingdom has not done that by statute, before, so my lords, I'm going to gently, just to foreshadow what I'm going to say.
Yes.
Privately, I'll just be completely open about this. Ground one, the short route by the judge, is not easy. And I rather agree. But I'm afraid I've slightly warmed to it for reasons that I will try and explain.
Right.
And I think those are that there's an express statutory intervention by Parliament to give effect to important international convention in 1966 before the SIA is even in place. There's a 12-year gap. So quite where that leads one to, one can debate. There are a number of different ways through that. But I don't think actually it's quite as much of an outlier as one might think. So I'm just gently trying to warm that up. Because one's initial reaction is everyone says the SIA is a complete code and so forth. And it obviously is, in the sense that it fully overlaps with what had already been done in 1966. But that doesn't mean that what was done in 1966 wasn't itself effective.
That sort of says it's not a complete code because
Well,
outside the SIA is the 1966
well,
Act.
my lord, I mean, if I was pushed, I would say actually on analysis, it's not a complete code in the sense that the 1966 Act did its own work. But it was perfectly obvious that they had in mind in the 78 Act the need to make sure that the 78 Act didn't preclude the operation of what had been agreed in 1966.
But that, I mean, this is, I know you've thought of all these things anyway, but
I don't know.
essentially that just means they thought that either Section 2 or Section 9 would apply.
Exactly. I think probably both.
Yeah, understood.
I mean, the only interesting thing on the Hansard point is obviously we respectfully say it helps us for the treaty was mentioned, but it's interesting that it's being used really partly about the meaning of the 66 Act, which of course the Solicitor General didn't actually mention. What he mentioned in Hansard was the existence of the treaty. He didn't mention the fact that the treaty had been implemented under the 66 Act, which we say is rather important because on our case, Parliament did not legislate in vain between 66 and 78, because we would have been in breach of our obligations under the Convention for two reasons. One, we would not be enforcing if an individual case came up, we would not be enforcing it as we should. But the key reason is under Article 69. Because if the 1966 Act was not effective to put in place the legislative or other measures necessary for making the provisions effective, then we were in breach in 1966.
Section 1, subsection 2, person seeking recognition or enforcement of such an award shall be entitled to have the award registered in the High Court, subject to proof of the prescribed matters and to the other provisions of this Act,
I'm coming.
and nothing else.
It's express.
And if it were the case that that somehow become also subject to the defendant being able to run a case of state immunity and escape completely free, then that really does
that runs
drive a coach and horses through the UK's obligations under Article 69.
Yes, and it goes directly against the express words of the statute,
Right.
which is sometimes got as quite difficult as well.
Right.
So, there, you know, this is, the more one looks at it, the more powerful the preclusion of sovereign immunity becomes. My lords, there is actually an anterior point, just going back to the basic principles of sovereign immunity. There's obviously that debate about whether we had the absolute doctrine or the restrictive doctrine of sovereign immunity.
Yeah.
And that's totally sterile for the purposes of this analysis, because there was some discussion between my Lord Justice Phillips and my learned friend Mr. Ballock about how awards might arise, I think also the Lordship as well, about how awards might arise against states and so forth. I mean, it's actually a three-stage analysis. The key point is that almost always, not always, but very frequently, the wrongful act that breaches the fair and equitable treatment standard or whatever the underlying treaty is, will be de jure imperii, not gestionis. So, no, Parliament had to pass the 66 Act because the natural quality of the acts in question was de jure imperii and not de jure gestionis. So there'd be sovereign acts, like we have in this case, where Spain removes all the support after everyone's built their green energy infrastructure on the promise of support. They go only joking and take it away again. So that is a classic sovereign act, and that is absolutely typical. So just the three stages of the analysis are, number one, the unlawful act in question will be a sovereign act, de jure imperii. Number two, an award will typically be, obviously, will always be against a state in that, on that analysis. And number three, there will therefore always be a question of sovereign immunity if it's not catered for by the convention and the implementing legislation in each contracting state, which is why the convention reads as it does and includes Article 69 to make it effective. And one asks this question, to which I respectfully say almost asking the question is dispositive, which is this: how on earth, let's take the premise of an investor investing in a state and being treated in breach of a fair and equitable treatment standard. Right? That's the premise. And the question is, what can the investor do about it? And the whole point of the convention was to enable machinery by which there could be an award that's actually enforceable against the delinquent. I don't mean that in a pejorative sense, but the state that is in breach of a standard in the treaty. And if you say that you are, I mean, the whole point of having this architecture, the ICSID architecture, is to take you away from the courts of the state that has treated you badly,
Yeah.
to mitigate sovereign risk, the purpose, which I'll come back to. And that purpose is entirely defeated if you have to depend as the investor on the goodwill of the delinquent state to waive immunity after you've spent a fortune getting your reward. So the entire convention, the whole purpose of the convention is totally frustrated.
Well, there was some suggestion when I sort of put that sort of point to Mr. Bullock yesterday, that the convention was somehow really dealing with disputes between states and investors, where the investor was the defendant. But I
Can I just
can understand
Yeah.
that, but surely it must be both sides of the coin. mustn't it?
Your Lordship's absolutely right. I want to be fair to them.
Yeah.
Against me, one of the focuses in the travaux was to make sure that states that won could enforce a costs order against the investor
Yep.
if the investor didn't pay. So they were very keen on that, understandably.
Yes.
But Schroer makes it absolutely clear, and we can see it in the report of the executive directors and so forth, it was always going to be based on equality for both sides.
Yeah.
So it was going to be, but it's completely true that one of the points they kept discussing was because of course it's a convention of states, it's not a convention of investors.
No.
So Aaron Broche was doing a jolly difficult job over quite a long period trying to get everyone to agree. And in the end, they agreed on the formula that we have before us, which reserved the question of execution to the laws of state immunity in the states in question. And everyone agreed that everything else otherwise would be enforceable both ways. And so the fact that the concern about enforcing costs orders against investors loomed larger in the debates is nothing to the point of what the purpose was, which is acknowledged in the commentary as for both. So because otherwise it doesn't work.
No.
And also the fact that what's said against me, I think, is that because it was assumed that states would pay, you didn't need that provision. But that's absolutely wrong. The point goes the other way. Because the states were assumed that they would all pay, no one minded a provision that it could be enforced against them if they didn't. Because assuming they'd pay, they never thought that would happen. So the more you press the assumed they pay thing, the more likely it is someone will go, well, of course. It's like being in the county court in a non-molestation order. The judge used to say, well, Mr. Green, did your client hit his wife? And you say no. He said, well, he won't mind giving an undertaking then, will he? It's exactly like that. I mean, that's the negotiation that Aaron Broche was doing to get to what we now see, which has been a hugely important international convention with over 150 contracting states, which has hugely contributed to the prosperity of the world by increasing capital flows, as the World Bank intended it would, because of the mitigation of sovereign risk and the protection of investment. And all of that is totally undermined if you have to rely on the goodwill of the delinquent state before you can get any money anywhere. It's the whole convention, the whole thing goes. So, with the greatest respect, their analysis simply cannot possibly be right. Otherwise, it's really the end of the convention. It's also obviously not what any other country has decided it means, apart from Tethian, which I'll come to, which is a bit of an amusing outlier. So we respectfully say the fact that you had Article 69, which is the sort of departure point for this, what is extremely important, because that's what leads to the Act.
Can I ask you in
Yes.
relation to the Act? Section 1 contains what I think you would say is important mandatory jurisdiction. Person seeking recognition or enforcement shall be entitled to have an award registered in the High Court.
Yes.
Then in section 2, effective award shall be the same force for the purposes of execution, and then various provisions including High Court shall have the same control and execution of the award. Now, on the face of it, that's the same mandatory wording, but we know that the state does have immunity, retains its immunity in relation to enforcement, execution.
Yes.
So I wonder how much weight we can put on a mandatory wording of sections 1 and sections 2 as overriding what would otherwise be immunity. Because that really takes us then back, doesn't it, to Article 55.
Yes.
And so at the end of the day,
It relies on Article. Well, I think it's quite a good. Sorry, not for me to say it's a good point, but I take the point fairly against me that some of these language used did not foresee these problems because the convention was so clear.
well,
And made a very clear distinction between the two.
But one does have to remember that this may be referring to judgments against the other, the non-state party.
It's to both.
Yes, but and hence why you would have references in section 2 to execution, which on the face of it might not apply against the state.
Yes. So
I think the only point I'm making is I'm not sure that the very strong, clear wording in 1 is necessarily a complete answer.
well, it may not take it there on its own because of the similar wording in 2. It may not in itself be a complete answer.
I mean, it shows one needs to reference what the convention says about state immunity.
Precisely. But I think that what one has to do that.
They're rather more nuanced.
Your Lordship's actually right. That's a very fair point about the structuring of the Act. I think, but I mean, it starts, of course, with Section 1.1, what the purpose is to do, which expressly references the Convention. So your Lordship's right that under the Convention, it is unusual because this is this two-way facing. You know, the Convention provides in 69 for domestic legislation, and the domestic legislation, unusually, because we normally have in our dualist system a slightly more separate arrangement between international conventions and domestic legislation.
So you referred it. I'm sorry.
Go on.
Let's take a new point.
I think I'm pursuing my Lord's point. So just to understand, in 1968, where would a state's immunity from execution have arisen from?
From the reference to the scheme of the Convention.
Well, where does it say that? Because it says the text is set out, but where does it say the Convention is to be treated as having the force of law?
Well, my Lord, it doesn't go that far, but the Supreme Court's analysis in Micula is that the Act was designed to implement the provisions of the Convention.
Which it obviously was, but I'm really pursuing
Yes.
my Lord's point. I
The,
mean,
dra- on
it
the,
looks
draft,
as
the
though-
drafting point is not clear. I agree.
I mean, it looks as though you've got to find immunity from execution outside the Act,
Yes,
leaving open the possibility that there might be immunity from something else outside the Act.
yes. So, but I think it is clear what Parliament was seeking to achieve, even if, I mean, I totally take the drafting point, it's a complete fair point, well made. But one has to look at it's highly artificial to look at the Act without the schedule, so with the Convention, the very clear provisions of the Convention, and that's the effect of the Supreme Court's decision in Micula. So, your Lordship's right. I mean,
And the effect of saying subject to the provisions of this Act doesn't of itself, bringing in Articles 54.3 and 55, So section 2 on its face doesn't seem to allow for state immunity at all.
Well, my lord, no. Save that. The point is that the pecuniary obligations, and just to answer, I think, possibly the drafting point.
Yeah.
Obviously, it could have been done a lot more simply. But the fact that what they do is they take what the pecuniary obligations are in the award and say that those find, under the convention, say that those then find expression in a judgment, means that the pecuniary obligations are confined by the terms of the convention, such that 55, for example, would operate on the terms of the judgment are defined by the relevant provisions of the convention. So that's how it comes in. But on, at first blush, I completely accept the drafting point. But
So the point being that it goes back to your point about this being, as it were, post-sovereign immunity issues. So
yes.
if there's an immunity issue in relation to enforcement under 54.3 or 55,
yes.
then it's already, as it were, being catered for.
Yes,
By
it's
the time you get to section 2.
Because the nature of those awards, the ICSID award, is defined by those provisions of the convention. And so the obligations arising from the award cannot be larger than those, cannot go beyond what's provided by 53 to 55. So that's the way it worked. But it was obviously be much more helpful. I mean, at the time, no one thought there was any doubt about it. This has only arisen, really, because of Acmair and Comstroy is the only reason that there's all this. And then other people have sort of started to take the point, warming to the theme. But for years, I think more than 50 years, everyone thought it meant the same thing. So the short point is that the judgment the final judgment you get here is delineated by the provisions of the ICSID Convention to which it's subject, and therefore is of no greater or lesser effect than as provided for by Articles 54 and 55 in all cases, and 53 insofar as relevant either in the contracting state or if there's an estoppel.
I'm slightly struggling with this because there's nothing in the convention, nor would you expect there to be, that qualifies the award in terms of how you can execute it.
No, my lord, no. But what it's the pecuniary obligations. So the pecuniary obligations which it imposes. So the award, that's your lordship's completely right, but when you look at what the pecuniary obligations that are imposed on a losing state party under 53, the losing state party is bound by Article 53. That's where we find important parts of the contents of those obligations. Because 53, they're bound. 54 and 55 obviously deal with the extent to which they have obligations which cut across state immunity, and 55 makes clear they don't on execution. So that's why I completely accept the vanilla drafting doesn't highlight the points, but it's I respectfully say quite obvious when you have the convention in the mind as the starting point, and that the obligations that spring from an ICSID award are the fruits of the provisions.
You're slightly arguing against yourself now, because your previous argument was it's very straightforward. You have the award, it's authenticated, you can register it. I think that's slightly backtracking from that and saying, well, when you look at the award, you have to have provisions of the convention in mind, etc.
I don't know.
I think.
Sorry.
I have some difficulty in interpreting the reference to an award and registering it as importing into that a restriction on execution against a state when it goes on to set out how it can be executed.
So, yeah, I'm sorry, could your lordship just repeat the question? I slightly lost my...
Don't worry.
Well, I was simply saying that, as I understand it, we have a simple award which can be authenticated and registered.
Yes.
And then Section 2 provides for enforcement of the pecuniary obligations to which it imposes on the state, and it imposes the obligations on the state whether or not it claims immunity from execution.
Yes.
So I'm not sure how one reads into Section 2 state immunity from execution at a prior stage to Section 2 providing for execution.
Well, I think this was obviously not the focus of the draftsman's attention because of the clarity of the convention. But I mean, I think making it work, the point is they deliberately chose registration rather than recognition as a word, just so as not to confuse courts. And in Schroer, there are the examples of the French courts, High Court of First Instance, getting it wrong because they're so used to dealing with New York awards and then being repeatedly overturned on appeal. But I think, no, it's not like in New York. So they specifically Parliament chose registration as a different word to comply with the obligation to recognise. And that means that you get your award recognised in all its glory. And that is empowered by 53 and 54, 1 and 2, and limited by 54, 3 and 55. Because that's what the force of the award is. The pecuniary obligations in the award are qualified by 54, 3 and 55.
Except that Section 2 says an award has the same force and effect for purposes of execution as if it had been a judgment of the High Court.
Indeed.
Which doesn't apply any qualification. It looks as though that's out and out enforceable.
Well, I think the only way one can make it work is to understand that the qualification on immunity is a qualification on the nature of the pecuniary obligation itself that springs from the convention. I completely accept that it's not. Looking back now, one could have done a better job in '66 to make that point clear, but it was very clear to everyone for over 50 years. So they did quite a good job until this point arose. But I accept it's not that easy. I mean, it's interesting that the final judgment wording came from, of course, the European Communities formulation in the Treaty of Rome, which, you know, certainly was nowhere near anything that might be interfered with as a recognition on adjudicative immunity by sovereign immunity. In fact, quite the very reverse. So that puts that, I respect to bed in that regard. My lords, is it a convenient moment to take a 5-minute break? So we're halfway through the afternoon nearly.
Yeah, we can certainly do that. Let's do that. Okay. Are you sort of moving on?
Yes, I'm actually going to carry on a little bit more. I'm going to move on to. I am going to move on. Yes.
Yeah, okay. Well, we take a 5-minute break.
Fraser J.
Christina, here are two strands of the property and not property. Anyway, correct.
Yeah. Yes. Has it continued? I think I'm coming today. And then the sound is completely weird. Then they can just come have a look after court just to. Yeah. So what is Shakira say? Sorry.
I'm just doing I read hearsay.
And this we've done out. I feel like he was considerate. Instead, we should be just shout.
The court couldn't give an answer to it. So where do you get the means of execution if it's not on
It's happened before. Is it just a 5-minute adjournment? What time do it? That's 5-minute adjournment. You don't have a 3-minute adjournment.
I don't think I'm sure he does. Right? If you look at my from yes, sorry,
I did see IT. Starting again at 3 o'clock. People that they do this with them. Is that accommodation also?
yes. What are you doing? Damaging myself. You teach your children not to do that.
Yeah. That's right. These are for the members of the court who haven't
That was
got
my thinking. No more telling. This is a workers' compensation claim, and someone's paying for it. Yeah, Sam was my mum.
One on Phillips' desk. Newey's got one on.
I broke that from last year as well. Dropped the catch. Bad on everybody.
Full recovery.
Just the end that broke. Not anywhere in the middle. Not when you're a child.
What right is able?
Well, it's kind of on that little point on drafting of section 1 and 2. Can I reflect overnight and give some further thoughts
Yeah,
tomorrow?
I mean, I'm not sure it matters at the end of the day.
It
in
may
the sense
not.
that if you're right about ground 2,
Yeah.
then you get home on ground 2.
Indeed, but I want to be fair to ground 1. I don't want to abandon ground 1 as soon as
No,
I'm in trouble, you know.
Yeah.
I'm a fair weather friend to ground 1. So this provision in the convention is dealt with by Professor Schroyer in volume 8,
right.
which is in tab 146. And it's on page 4342 in tab 146. So certainly the intention under the heading Final Judgment of Domestic Court, the intention is clear. The reference to a final judgment of court in the state where enforcement is sought is contained in the preliminary draft and all subsequent drafts. Mr. Brocious explained that this would leave the rules on state immunity from execution unaffected. So it's right just to be clear that 55 came along quite late as just a bit of reassurance about 54.3, just to make sure that no one was worried that 54.3 could be interpreted in the way that. So 55 wasn't originally there, and it was a later bit of reassurance
Yes, okay. Yeah,
to get.
understood. That's good.
And what Professor Schroyer says there, so 4 lines down underneath Mr. Broche, it would simply put an award on the same footing as a final judgment of the national courts. If such a judgment could be enforced under the domestic law in question, so could the award. If that judgment could not be so enforced, neither could the award. So that's at the effect of the execution stage. And one of the difficulties linguistically is that in these there are the phrase enforce and execute are used slightly interchangeably in a lot of the discussions, because different people from different countries use them in different ways. And actually, you can see in the Travaux, even the same people using the same thing slightly interchangeably. But the point was catered for by 54.3 and Article 55 on execution.
Yeah.
And then a bit further down, underneath the history, the highest court or superior court suggestions were not successful, but proposals to remove the reference to a final judgment of a local court altogether or replace it by a reference to a local arbitral award or a foreign judgment were defeated in 3 separate votes. So just in terms of the genesis of the convention, this is very much a convention where these matters were at times quite hard fought. And what survived is something to which an enormous amount of thought was given and now finds expression in Articles 53 to 55. Proposals, so the change from the original plural, the courts, to singular, appears to be purely a matter of drafting convenience without practical significance. And then he refers to the report of the executive directors at the top of 4343. It restates the position. The doctrine of sovereign immunity may prevent forced execution in a state of judgments obtained against foreign states or against the state in which execution is sought. Article 54 requires contracting states to equate an award rendered pursuant to the convention with a final judgment of its own courts. It does not require them to go beyond that and undertake forced execution of awards rendered pursuant to the convention in cases in which final judgments could not be executed. And pausing there, my lords, just as a parenthetical note on Zimbabwe's promise to trawl through the travaux preparatoires, we did an awful lot of that in Micula, and the Supreme Court has said what they show in Micula, which I can take you to later. And I respectfully suggest that what the report of the executive directors themselves said it meant, where they'd got to, and the Supreme Court judgment together are conclusive and unlikely to be displaced by a close analysis of the arguments in the travaux.
The executive directors are the executive directors of the World Bank, are they?
No, on the convention, the executive
on
directors.
The convention.
Yeah. So that's
Who are they?
they were the executive directors of basically the project to establish the ICSID convention.
Well, that's rather. I find that rather odd because their report is in 1993, so it's actually 27 years later.
Well, there's an ongoing.
There's an ongoing. Okay.
We've got. I mean, there are various historical.
Don't worry.
I will be showing you a couple of them tomorrow, but
Okay.
but the Supreme Court obviously looked at the travaux very carefully in Micula to see what the effect of that was.
Okay.
We'll come to Micula. Then, if we can look at 4354. If we look at paragraph 149 on the top of that page, many states have designated those courts or authorities that are also competent to deal with recognition enforcement. This, however, carries the danger of ICSID awards being subjected by those courts to the same procedures or standards of review as other awards of foreign judgments. The result would be inconsistent with the finality and non-reviewability of ICSID awards, and that's one of the problem cases in France. And then at 150, this is in relation to 54.3, which is mirrored and clarified by 55. The earliest drafts did not contain a provision comparable to 54.3. So it basically went 54.1 and 2. Well, it's not quite as simple as this, but then 54.3 and then 55 to make it absolutely clear. So again, this was something that a lot of thought was given to, which very powerfully weighs against the suggestion that adjudicative immunity was just simply not thought about, because that was the entire premise of the need for the parties to agree in the first place. So the application of local law on execution seemed implicitly to follow from equating ICSID awards to local judgments. And I think that's the premise. I'll come back to it tomorrow, but the premise in section 2 of the Act is that on execution, the idea of the convention was to leave local laws on execution in place and leave that as a matter for the courts of the country in which the award was sought to be enforced. there was consensus that the application of local procedural law implied that the only means and methods for execution of that local law, that only the means and methods for execution of that local law would be available. Article 192 of the Treaty of Rome, which we've looked at elsewhere as well, served as a model for the first draft, which provided that execution would be governed by the rules of civil procedure in force in the state in whose territory such execution is sought. After some more debate on the significance of different procedural rules on execution and the different types of execution available in states, it was agreed that execution would only be available in respect of pecuniary obligations. And that was because there was a concern about, two concerns. One was injunctive relief forcing states to take specific action, and the other was relief granted by a tribunal that might not be actually available in the country which is sought to be enforced.
Yeah.
So they're then not in a position with their domestic law to enforce it. And it would also mean that Article 69, had they included the whole panoply of possible remedies to be enforced rather than just pecuniary obligations, 69 would have required contracting states to pass a statute effectively amplifying what remedies their courts could give. So for all those reasons, and as part of the give and take between the contracting parties and the putative investors, they were confined to pecuniary obligations. My lords, it's right also that the court should have in mind that as well as the layer between states and investors, there was actually sort of a dividing line in the negotiations between the capital exporting countries and the predominantly capital receiving countries. So that was another part of the negotiations that took place. And indeed, in the Hansard extract, which we had before Mr. Justice Fraser, we saw the bill being, the 1966 Act, the bill for it being promoted by the relevant minister, referring to the fact that it was good for the United Kingdom because we were a capital exporting country. So we're going to get advantage from having our investments protected. Well, it's inconceivable that Parliament would have thought that giving that right here would be different to the benefit we would get there. And it rather goes to this effectiveness point, that the whole premise of the convention was the protection of these investments so that capital flows would increase to the mutual prosperity of all contracting states and the world. So my lords, that brings me to the civil procedure rules, if I may. Mm-hmm. And there is a small point of detail. A learned friend Mr. Moulan, in his skeleton, at paragraph 54, sets out an elegant analysis of the CPR provisions on pages 16 and 17. His supplementary skeleton. Paragraph 54 on page 16. And sorry, this is the first one. Apologies.
Is it the first skeleton?
Apologies, it's the first one.
It is the first skeleton.
16 and 17, I apologise. This was the...
Yes, it's
Yeah.
6221.
Yes, exactly. Para 54. And parenthetically, although Mrs. Justice Darcy's father was an absolute hero, without whom I wouldn't even be in the profession, we respectfully agree that the decision that it's not an adjudicative act is wrong. It plainly is, for the reasons, not least for the reasons that we put at in the postscript of our skeleton argument, because what the court's required to do is to make an award, register the award in the amount, in an amount which includes a, and it's at the back of our skeleton argument if it's helpful.
Yes.
At paragraph 86, although no judicial discretion is exercised in relation to the award itself, for all the reasons the court's already heard, the respondents would respectfully submit the better view is that making of a registration order by the court is an exercise of adjudicative jurisdiction, including checking the prescribed matters, which is the authenticity, and I'll show the court the rules in a second, and whether there's been a stay, determining the sum in which the award should be registered, including as to allowing reasonable costs of and incidental to registration, and probably rather importantly, reducing the sum in which the award is to be registered by any partial recovery, and those are references to the provisions in the Act that require the court to do that. So we respectfully submit that Mrs. Justice Stiles' decision that the registration of the award is administrative, not adjudicative, is not correct for those reasons. The relevant CPR provisions are in tab 5 in bundle 1. If you keep Malone Friend's skeleton out, I'll return to it in a minute. But we can see 6221 is the rule on page 67, and the Act is the Act. The award means an award under the convention, and then defines the convention, and it says there, subject to provisions of this rule, the following provisions of Part 74 apply, and the court will see there at E 74.92. Now, Malone Friend's skeleton argument, which we finally tracked down, was the original one. Apologies for that. Emphasises the importance of 74.92 in paragraph 54.1b on page 17. And he says there, what is more, 74.92 is incorporated. That stipulates that no steps may be taken to enforce the award until the expiry of the time period allowed for the set-aside application. In other words, there's a safe harbour built into the CPR scheme for orders under the 1966 Act, which allows for a set-aside application to be made, with the grounds available for set-aside, setting aside the orders for which Part 74 was drafted not read across, because they don't apply. Now, with the greatest respect, we submit that's actually not quite right, and it's not anyone's fault. But there's a mistake in the rules, which I can show the court, which is at the back of bundle 9. Sorry, let me just find, yeah, it's tab 161. And what I've done is I've included there the statutory instrument itself. But the easy way to look at it is to start on page 4771, which is the front page of the White Book 2015. If the court has that.
Yeah.
So the member of Chambers who kept both volumes of 2015 was very pleased they'd finally come in handy. And if we go over the page.
We have white books that go back to, in the building, we've got the white book right way back to before it was, when it was still the Supreme Court practice.
Really?
I've still got the 1999 white book. Occasionally I get it off
The one,
shelf
the original.
and stroke it fondly and think, my goodness me, everything you needed was in the volume that wide.
Well, this arises from the amendments, so it's rather
These
on
are
point.
amendments that were introduced by that statutory instrument.
Yes,
Is that
they
right?
were, exactly. I can show the court that, but the simple
2014.
point is a visual one, actually, initially.
Yes.
It's visible from those 2 pages, which is the court can see that in the 2015 White Book, 6221 2E was the same,
Yes.
74.92,
Yes.
and points across the page
Yeah.
to 74.92. And that says any party wishing to enforce a judgment to which the judgment's regulation does not apply must file evidence of the service of the judge on the judgment debtor, the registration order and any other orders. And that is now 79.3, but they haven't updated the cross-reference in 6221. So what's happened, you can see from the statutory instrument, is 74.9 on page 4765. You can see what is now the bottom hole punch, 74.93, is any party wishing to enforce a judgment to which the judgment's regulation does not apply must file evidence of the service. So that is what used to be 74.92, and it was nudged down one subsection by the insertion of section 2 there. Sorry, insertion of section.
Well, what seems to have happened is if you look at
It's
the
renumbered.
2015 White Book,
Yeah, it was
the beginning
A1.
of it was A1, so the
Exactly.
opening words were A1, and then 1 and 2. And they
It-
simply made A1 into 1. and,
Exactly.
1 into 2, etc.
They renumbered, but they didn't.
So
the
the
substantive.
time period given by what is now 7492 was never intended to be
No.
applicable. That's your
No.
point.
And exactly. So the safe harbour submission in support of the fact there's sovereign immunity in that is wrong
Right.
on the face of the rules. Well, not on the face of the rules, but when you
No.
work out that the renumbering didn't work. So, and
Is that still, that rule still in the current White Book? Is that still
it is.
incorrectly?
It is still incorrect. I believe it's still incorrect. Yeah, it's still incorrectly numbered.
Well, I will raise that with the Roles Building Subcommittee and the Civil Procedure Rules Committee, so they get it corrected.
I'm grateful, my lord. The short point on the underlying rules is that it's basically a closed and specific procedure, as the Supreme Court noted in Micula. And it's specific to these awards. And there was specific provision in the 66 Act for the making of specific rules for this purpose. So that is the chain by which Article 69 was complied with through the 66 Act, and the closed procedure of these rules, which have been used in all the cases since. It does give rise to one point, which is, as I understand it, on the sovereign states side, their case is that the court is always required to consider state immunity, and that means that maybe it's a question that disappears in itself, but I think on their analysis, the failure of the courts, if there has been a failure, to recognise sovereign immunity at the pre-registration stage has been an error by every court that's dealt with an ICSID case, because that must follow. If they are right, and there is sovereign immunity, then all of the courts to which we referred, certainly at least the courts to which we referred in our skeleton argument,
Which,
it's at page 402, paragraph 16.
yeah,
Little a. Firstly, to its knowledge, Spain asserts that this is the first decision to hold the SIA doesn't apply to a class of action against a foreign state. And I understand that's the ground one point, and that's a fair comment. But in fact, only immunity from execution has ever been issue in an ICSID award enforcement cases prior to this joint appeal. And there are the decisions of Mr. Justice Akins, there are all the decisions in Micula, and there's the decision of Mr. Justice Jacobs in Union Fenosagas
yeah,
as well. And no one has thought that registration should not take place for reasons of sovereign immunity. And that sort of slightly foreshadows a point on the interplay between the SIA and the 1966 Act, which is a ground one, ground two point.
yeah.
It may not matter very much in the results, but to the extent, one way of looking at it is to the extent that the 78 Act asks a question, the 66 Act answers the question by parliamentary intervention, we would respectfully say. So that's one analysis on the ground one point. But it's very clear that where there's a statute making express provision for the registration, of the awards as a judgment, and the civil procedure rules that are made under that statute then give very specific procedure by which the judge is to do that. We respectfully say there is no room for a construction of the Convention, the 66 Act and the rules as reflecting the availability of a sovereign immunity objection at that stage. Because otherwise the Act would say something different and so would the rules. Or the United Kingdom would be in breach of Article 69 of the Convention by having failed to legislate so that the award could be recognised at the adjudicative stage. So those are the only options. Either the United Kingdom's in breach in failing to legislate adequately, or the domestic legislation, which I accept there's a couple of nuances on the drafting, but is effective to achieve what the United Kingdom was obliged to achieve under the Convention. Wells, can I take the court very kindly to volume 6, please, to the decision of the High Court of Australia, which we find at tab 89. Find 6, please. And so these are the references I've identified on the reference sheet at 11. And if we go to paragraph 31 at page 3109 first, I think Zimbabwe disputes, the purpose of the convention as being limited to the creation of facilities. We respectfully for our part say that it's obvious what the true underlying purpose of the convention was. And we say that that's also supported by the analysis of the High Court of Australia at 3109, particularly you see paragraph 31 referring to the history of the ICSID Convention. It's explained how it had become increasingly clear during the 1960s that the growth plans of developing countries would need to rely upon international private investment as well as external government sources. To encourage such investments, competent international organisations considered several schemes designed to remove some of the uncertainties and obstacles that faced investors in any foreign country, and in particular in many of the states that only recently attained independence and self-government, and whose need for outside capital was greatest. So that is making the capital point clear. If we go over the page to 3110 to 3111, if we look at the top of the page, the summary record of proceedings of the first consultative meeting at Addis Ababa records Mr. Broch's repeating the concern of developing countries that one of the most serious impediments to the flow of private capital was the fear of investors that their investment would be exposed to political risks such as outright expropriation, government interference and non-observance by the host government of contractual undertakings on the basis of which the investment had been made. And you can see there's a revised draft of 33 and then 34, importantly. The primary purpose of the ICSID Convention was and remains to promote the flow of private capital to sovereign nations, especially developing countries, by the mitigation of sovereign risk. So we respectfully say that is a reasonable purpose for us to contend lies underneath the Convention, and it's one that the High Court of Australia also itself accepted. And it refers there in the footnote at 55 to the report of the executive directors on the convention, on the ICSID Convention, 1965, paragraphs 40 to 41, and a couple of others. And then, just finally on that point, paragraph 40 on page 3113, the terms of Articles 53 to 55, Articles 53 to 55 of the ICSID Convention, which have the force of law in Australia, are a central plank in giving effect to the primary object of the ICSID Convention to encourage private international investment, including by mitigating sovereign risk and providing an investor with the legal security required for an investment decision, which is then refers to Schroer's commentary, 3rd edition, which obviously we have before the court. So we respectfully say that the purpose of the convention, on which I've already made submissions, is absolutely central to the proper construction, obviously, of the convention itself and its implementing legislation, which was implemented pursuant to Article 69. And that is in mitigation of sovereign risk entirely undone if there is sovereign immunity at the adjudicative stage. So it's not a marginal purpose that's defeated, it's the central purpose. It's one side of the coin of the central purpose of the convention, without which the other side won't happen. So
it rather undermines as well as the submission which was made to us that the convention was primarily looking at claims by states against investors.
Yeah, my lord, I think to be fair, my learned friend may have been thinking of the fact that a concern in negotiation was enforcement of cost orders by states. I think that would be a fair, that's I think correct, that loomed large in the travaux and the negotiations. But it's not, the wider submission is not correct. The whole point is when you risk something which is de jure imperii in almost all the time, likely to be classified as that, a sovereign act that takes away the value of your investment by hook or by crook, you need protection against that and reassurance.
Well, what we can say is that it's mutual, a mutual confidence,
Exactly.
which appears in 34.
Exactly. Well, that's the short summary.
In one way in which you don't mitigate sovereign risk is by allowing sovereign states to rely on sovereign immunity.
Well, particularly when they're the person you're complaining about.
Well, precisely.
I mean, it's almost comical, the idea that, right, you're going to be okay, states treated you badly, we'll give you something that you can only enforce with the agreement of the person who's treated you badly. I mean, it doesn't even pass the red face test, we respectfully submit.
No.
It's hopeless.
But are we still looking at the position now on your submissions pre the 78 Act?
Well, we are, and I'll come to the 78 Act very shortly. But we respectfully say that had to be the law even prior to 1978. And that's why ground one, I understand that there's some drafting nuances and so forth, but when you look at the scheme as a whole, through the portal of Article 69, giving legislative effect domestically to the convention, the incorporation of the idea of the content of the award being registered, and the clear intent to preserve such immunity from execution as any particular party may have, according to local law, it works. It was designed to work. It had to work. It's the UK's obligation that it should work, and they did it. And that's it. And they certainly did not legislate in the 66 Act totally in vain to wait for the 78 Act to come along and give it some teeth. Because, I mean, one does need to confront what was the position. Now, the sovereign states need to be able to tell the court what their answer is. What's the position in 1967? Did it not work? Well, was the United Kingdom in breach of Article 69? Just signed up? We say no, it wasn't. And that's why ground one, initially a bit difficult, seems to be actually, in a way, an attempt, at least, and understood to be a clear parliamentary intervention to ensure that these were the threat, the sort of the dike of adjudicative jurisdiction and sovereign immunity is jumped.
But now you've got to deal with the 78 Act.
And now I've got to deal with the 78 Act. Yeah, absolutely. So that's the submission based on getting us up to that point. So par and pillar one, the short point there is nothing to stop states making a treaty by which they submit to each other. Good example, Treaty of Rome. As it happens, that's what they used for 54-1. Then ICSID Convention and the Act, absolutely clear, it's plain words. The contracting parties were agreeing with each other what they would do. And that's reinforced, obviously, by 41, with the tribunal being the judge of its own jurisdiction at one end, and at the other end, 69, the obligation on the contracting states to legislate effectively. And so we have to interpret it, as the Supreme Court did, as effective legislation to implement the commission of the convention. So I now turn, my lord, to 1978 Act, if I may. And that is a, well, I think we know what the provisions say. We probably don't need to look at them. But the short point is that there is a, this might slightly cut across, I'm not sure, my learned friend Mr. Harris's submissions on the effect of 23. There's every likelihood he's right, not me, but I will explain what our submissions are on the Act, if I may. It's at tab 4 in bundle 1. And pausing there, I will take the court to the later judgment of Lord Sumption. I think it's in Ben Carpouche, I can't remember, and I'll take the court to the right judgment at the right moment. But Lord Sumption basically says, look, of course everyone knows the State Immunity Act is very important and so forth, and there's a primary preclusion in section 1, and then there are all these exceptions. But that's really a drafting technique, and one shouldn't be overly distracted by a drafting technique rather than and regard that as substantive law. And I'll take the court to that in due course, but I'll foreshadow it simply by saying that's a point I will make, just when considering, of course, what the SIA did was to say, you've still got sovereign immunity on the pattern described in the Act, which is you have it under 1 unless you don't have it under the relevant exceptions.
Yeah.
But it's a little bit, it may not be a helpful signpost to regard section 1 as something terribly difficult to detract from. The SIA was really trying to just lay out the ground in a sensible drafting structure. Then we get subsection 2, which the court's already had submissions on, so I'll try and take it reasonably briefly. Submission to jurisdiction, a state's not immune as respects proceedings in respect of which is submitted to the jurisdiction of the courts of the United Kingdom, which we say is inevitably the case under ICSID, because that's exactly what the convention says for all the reasons I've already identified. And then obviously the points the court's already canvassed with my learned friend, may submit after the dispute or by a prior written agreement, which we've got in 2.2. As to 2.2, the prior written agreement, which we've already looked at as well, is in 17.2. It's on page 60, sections 2.2 and 13.3 above. In those sections, references to an agreement include references to a treaty, convention, or other international agreement. And also, this is both crystallising the position in statutory form, but it's also utterly consistent and consonant with the pre-existence of an effective 66 Act. So we respectfully say that to the extent that the way the SIA was drafted fully accommodates the pre-existence of an effective 66 Act, it's not inconsistent with the ground 1 argument. There is a slight wrinkle, the temporal wrinkle, about which the court will hear more in the Zimbabwe appeal, but it's on section 23, which we find on page 63 in the bundle. And that provides, and it doesn't actually matter for the parties in this case, but the general principle does invite some careful thought, I think. 23.3 says, subject to section 4 below, parts 1 and 2 of this Act do not apply to proceedings in respect of matters that occurred before the date of the coming into force of this Act. And in particular, sections 2.2 and 13.3 do not apply to any prior agreement. So just pausing there, as it happens, Spain acceded to ICSID after the 78 Act. So it doesn't matter.
Right.
But on our friend, ground 1, who I don't want to leave on his own over there, it does require one to think a bit carefully. I mean, there are lots of countries, I can't remember what the number was by 1978, that had acceded to the ICSID Convention, but it was in the tens. And the question is, was the idea that section 2.2 would not operate in relation to countries that had joined the ICSID Convention at that stage? And on one view, and I understand this is a nuanced submission, I think my own friend Mr. Moulin describes it as an unsatisfactory way to present an appeal to the Court of Appeal, so I apologise, I'm not reaching his heights. But it is slightly nuanced, but there's a 1966 Act that's clear and does its work. And then there's a codifying State Immunity Act, which is clearly not intended to abrogate or repeal the provisions of the 66 Act, and is perfectly capable of either accommodating the arbitral awards in Section 9, to which of course all the EU arguments would apply, or in Section 2, to which they would not apply, we say. Or the third analysis is ground 1, which is to say that actually, in predating the SIA by 12 years, and effectively legislating to jump over the gate or the dike or whatever one wants to call it, of determining whether sovereign immunity was available, the 1966 Act did that work at that time, and there was nothing in the 78 Act intended to disrupt that. And therefore, Section 9 was changed to make sure people wouldn't think that it had somehow interfered with the 66 Act, because it might look inconsistent. But that is the sort of harmonious construction which we would urge on the court under ground 1. And I rather accept my Lord the Chancellor's point that it is not an easy, I don't say it's the easiest or most obvious one that comes to mind first, but when one looks at it, you've got this temporal gap from 66 to 78, which has to be explained. It obviously doesn't rise in our case now, but on analysis, one has to say, well, what was the effect of the 66 Act between 66 and 78? And we respectfully say, because of Article 69 and the analysis of the Convention, there's only one answer, and that is that it was effective to ensure that the United Kingdom complied with its obligations under the Convention, both in every respect. And therefore that meant that the CPR and those provisions have remained, the fundamental provisions and the narrow procedure have remained pretty much the same over the years. Basically, the statutory jumping of the gate over the question of sovereignty is a unique point to a unique convention. And it's for that reason that we would invite the court perhaps to consider the ground 1 perhaps more warmly than one might initially think. Because otherwise you're left with a surprising gap on one view between 66 and 78, which has to be accounted for somehow. And the only available answer, we say, for the reasons I've just given, is that the 66 Act was effective to achieve its objectives between 66 and 78. It wasn't one-sided. There was mutuality, as my Lord Justice Phillips has just observed. And it was effective to do that. It did it by giving clear instructions. The award should be registered. And that was the wording used to comply with the obligation in 54 that it be recognised. So that's what we say. And of course, if that's right, it does mean that all the court is doing is abiding by what Parliament said in the 66 Act. There's no great heresy in doing so, and it's harmonious construction of the two acts side by side. It also avoids the Section 2 problem, if one ended up being confined to Section 2, of having different strokes for different folks, having different results depending on when people joined the ICSID Convention. And that has an attraction of simplicity and good sense about it, which we respectfully commend to the court. And I do realise ground 1 isn't the easiest one.
Just going back to Section 23, subsection 3 for a moment.
Yes.
What's it really driving at? I mean, it does not apply parts 1 and 2. So there's a whole of part 1. So the whole of sections
everything.
1 to, where does part 1 end? 1 to 17.
Yeah.
Don't apply at all to proceedings in respect of matters that occurred before the date of the coming into force of this Act. I mean, if that was all it said, I mean, the reference to section 2.2 and 13.3, I'm not sure I understand why that's been done, really. But you'd say that's simply, is that doing any more than simply making it clear it's not intended to be retrospective?
Yes, I mean, again, my lords, with the greatest respect to the parliamentary draftsman, it's not absolutely clear what it is intended to do.
Because proceedings in respect of matters that occurred before the date
Sounds
of the
like
coming into the Act don't seem to me to naturally, at least, include the passing of a statute.
No,
It's talking about
or the
proceedings
joining of a
in respect of
convention.
matters, so something's
Yes.
actually happened.
Yes,
Some dispute that has arisen
yes,
prior to the coming into force in 1978.
exactly.
And it's simply saying
Yeah, it's not
this Act doesn't
retrospective.
apply to any of that.
Exactly.
Because it's all pre-Act.
Yes. So,
What's the significance of subsection 4? Because this is subject to subsection 4.
Section 12. Didn't seem on the face of it to really.
well, section 12 is the provision. I mean, section 12 has been hotly debated, but not in our case.
Yes, I see.
So,
Thank
my
you.
lord-
Let's not worry about it.
I'm applying for an exemption from that
particular.
particular.
Yeah.
I mean, there's quite a lot of law on it,
Hmm.
but I haven't focused on it. But I mean, it is interesting. So it's not quite clear, but on your lordship's analysis, which I think I would be glad to embrace, if all it is saying in section 23(3)(a) is it's not retrospective, the question arises as to what happens in proceedings that started in 1975, as an example, and are still ongoing when this Act comes into force, or 1976. So by that stage, you've got, just looking at the international scene for a moment, you've got 1957, the original European Treaty of Rome. Then you go through to 66, where they borrow a provision put into 54, and you get the Act. And then you get a dispute arising in 75, by which time the United Kingdom itself has joined the European Community by the 72 Act at the beginning of 1973, and also entered into a treaty with a provision mirroring the basis on which Article 4 was extracted. So by that stage, it would seem a bit strange if there was some real objection on the basis of sovereign immunity in 1975, or that the passing of the 78 Act would somehow mean that you couldn't go ahead unless you fitted in with Section 9.
It's very odd, isn't it?
So, precluding you relying on Section 2. So, again, it's not conventional because, of course, apart from this one outlier of a specific act and a specific convention, the State Immunity Act is a complete code. And so for all purposes, that's what's been said in all the cases. But none of the cases considered specifically whether the 66 Act itself did that work. So none of the cases in which it's been said it's a 78 Act's a complete code had in mind the gap between 66 and 78 for these purposes.
Yeah.
So that's, sorry.
Considering possibly the analysis of what happened in 66, at that stage, state immunity is a common law construct.
Indeed.
So a common law construct can plainly be overridden by a statute.
Well, precisely. Sorry.
Yes. So the provisions of the 66 Act, you would argue, plainly override the common law immunity.
My lord, yes.
So then what happens in 78
is that common law immunity is put onto a statutory footing.
Indeed.
So what happens to a statutory abrogation of a common law immunity once the immunity is put onto a statutory footing?
So, my lord, that's a perfectly normal process of statutory interpretation. My learned friends included Benyon, the presumption against implied repeal in Benyon, which is well known. We can look at it. I can find
It's
it.
not a matter of repeal, is it? It's nobody's suggesting that the 66 Act has been implicitly repealed. The question is, how do you interpret? It seems to me it could be done in one of two ways. You either say, well, the turning of a common law immunity into a statutory immunity cannot be interpreted as affecting a statutory abrogation of the common law immunity.
Exactly.
Or you say, well, yes, it does, but not surprisingly,
They make a
drafted in a way
exactly
that
comprehends its continued
only-
effect.
Yes.
Yeah.
Commits its intended effect.
Yes. Those were the two things which less eloquently I sought to sort of vaguely set out at the beginning, but those are the two different analyses. And I have to say, be perfectly candid, I'm beginning to favour the former, which is
the ground one.
the ground one, because it's simple. It means that there's total clarity about what the United Kingdom did under Article 69 in the 66 Act. The idea, sorry,
The 23(3) point,
yes,
as I understand it, the effect of that would be you'd be back to the common law, wouldn't you?
if it had, yes,
So in fact, that wouldn't cause a problem with the 66 Act then.
no, exactly.
So that then isn't an answer to Section 2 being the right route.
No, on that formulation, my lord, no, that's right. So that may mean that Section 2, I mean, I think the reality is, I mean, obviously the court's got to decide this in a binary way, but the reality is it looks as if Parliament could see what the 66 Act requires and just wanted to make sure that, yes, the State Immunity Act wasn't drafted in such a way as to interfere with it, which is, I think, possibly more like Your Lordship's second. I mean, it's both. It's really both.
Well, we know the intention was not to interfere with it because
Yes.
of the Hansard extract.
Exactly.
But I think that was being used against you to say, well, it was Section 9 was viewed as the route.
But that
I don't
that's
think it says that.
no. It's incomplete in that regard. I mean, what they were saying, the use of Hansard. First, it didn't refer to the 66 Act, so it's not really relevant to. It's not promoting the 66 Act. It's promoting the SIA. It didn't refer to the 66 Act.
The exit treaty.
No, the Hansard was not promoting the ICSID Treaty or the 66 Act because it's about what they should do for the SIA. And it's referring back.
Yeah.
But the Solicitor General didn't refer to the 66 Act, but he obviously was aware of the treaty and made a brief remark to explain that we needed to make sure that ensure that didn't cut across that treaty obligation. So it's not massively pepper and heart compliant in the way that a learned friend wants to use it. And insofar as it is, it helps us.
Well, it only helps you on the Section 9 route, doesn't it?
No, indeed, my lord, yes. But what we would say is it certainly doesn't confine the routes available to us to Section 9 only, which is what I think Spain want to do it. It doesn't do that. And it doesn't have the sort of clarity that one had in Pepper and Hart, where they said, if these schools give the staff free things, they'll be charged at marginal cost. And then HMRC said, oh, it's something different. is miles away from that. I accept Mr. Moulin's point that, you know, general consultative reports and so forth can set the background of the mischief at which legislation is aimed. I'm not trying to be too technical about it, but it is fair to observe it falls miles short of Pepper and Hart for the purpose that Spain invokes it. But my lord, your point of the two, and it's quite subtle, the distinction's quite subtle. And ground one is more the first route, and ground two is consistent with the second route.
I mean, in terms of ground one, section 1.1 says in blanket terms, a state is immune except as we see in the Act.
Yes.
And it doesn't say subject to the 1966 Act or anything.
No.
It looks blanket.
No, I totally fairly say, and that tends to suggest ground two rather than ground. I mean, I completely accept that, but the approach to harmonious construction would certainly permits the court to say, yes, it does say that, but we also recognise that there was the 1966 Act, and actually reading the two together, it's clear that that actually wasn't intended. Because it's essentially lex specialis, very specialis in this case. I mean, it's a unique provision, really. And at the time, it was even more unique than it is now. So it wasn't really front and centre of consideration in that respect. And I appreciate your lordship's absolutely right. I mean, I readily accept what's on the face of Section 1 of the 78 Act.
And just going off at a tangent
Yes,
for a moment.
of course.
I've seen references to the 78 Act being intended to give effect to the European Convention.
Well, that's not quite
It's not
right.
quite
No, it's not right at all.
Good.
There's plenty of. I mean, if anyone seriously
It's not
contends,
intended to marry up.
no, absolutely not. And that we departed from it in a number of respects. And we're not taking the court to all the cases, but I think we have put them in case you want to see them. So I'm sorry that the volume of material, but it is all there if we need to go to it. But it definitely doesn't replicate it. And indeed, there wasn't any tie-in like we have the unusual tie-in with the Convention and the 66 Act. There was no tie-in of that sort either.
No.
So that's that. I'm getting on reasonably well, my lords. Could I take the court to Tethian? Just to have a little light relief for a moment.
British Virgin Islands.
Yes, it is, yeah. So that's the bottom one. It's number 18 on the reference sheet. It's at tab 6. Sorry, volume 6, apologies. Volume 6, tab 86. So what had happened, just to tee up what might generously be described as a car crash, was that an ex parte relief exercising both adjudicative and execution jurisdiction had been granted against a sovereign state on the basis of an award against another party, with a question as to whether that could be approximated to the sovereign state. And that was granted under a statute that had not yet come into effect. And so by the time the learned judge had heard Mr. Vernon Flynn's eloquent submissions about this, all was already lost. So he could be forgiven slightly by the time we get to paragraph 50 and 51 for dealing with this quite shortly on page 3031. Although I think the statutory instrument extending the 1966 Act to the British Virgin Islands was mentioned, it doesn't feature in the judge's reasoning at 50 and 51. So, the entire case had already collapsed long before we get to this bit. because the statute under which the relief had been granted hadn't actually come into effect yet. But at 1551, TCC advanced a new case as a substantive return date. This was trying to sort of save their position. That there was a submission by agreement in the ICSID Convention itself. This is said to be clear from all the textbooks and the case law. However, the ICSID Convention is a treaty that can have no effect under domestic law in and of itself. That includes, for present purposes, the United Kingdom position on state immunity, which is set out in the SIA. So there's no reference to the terms of in the judgment, in terms of the 66 Act at all. That was extended to the BVIs by the statutory instrument. I nearly added it to the bundle. I can give it to the court tomorrow if the court wants to see it. But the short point is the Act wasn't referred to, and nor was Micula, which had already been decided by the Supreme Court by the date of this judgment. So we would respectfully say this is not very weighty authority against the decisions of all other major jurisdictions that have held the opposite.
Yeah.
So that's Tethium. My lords, could we look at Micula if the court's got the energy at this time of the afternoon for one last push, or would the court prefer to deal with it tomorrow morning? I'm doing pretty well.
Well, I think we should go on till 4:15.
I'm most grateful. That's helpful. So if we turn to Micula, it's volume 4, tab 45. So the court will have noted that reluctantly we have suggested that in this area the lack of comity shown by the EU has been extreme, and that was not lightly included in our skeleton argument. In Micula, what had happened was the Romania had entered into a bilateral investment treaty with Sweden. The reason Romania had done that was because under the Europe agreement, the EU required candidate member states to do certain things to warm up their economies and align their practices in preparation for membership of the EU. And one of the things they were required to do, or encouraged to do, was to enter into bilateral investment treaties to encourage inward investment. And obviously that has the other benefit of aligning state practice with what might be more familiar in the existing member states.
Right.
So Romania entered into that, and the investors made their investments, and Romania promised them a 10-year tax subsidy if they kept their factory there for 20 years. And it was in a very deprived part of Romania. And then Romania pulled the tax subsidies, rather as we have in the Spain case, after about 5 years. And this was all when all of this took place when Romania was not a member state of the EU. And indeed the arbitration commenced when Romania was not a member state of the EU. And then Romania joined the EU, and the award came out when Romania was a member state of the EU, at which point the Commission enjoined Romania from paying the award on the basis that it was state aid. The grant of new unlawful state aid. Now, there were a number of points about whether being compelled to pay an award for something you did before you were a member state is the grant of anything.
Let alone
Let alone
being encouraged to do it by the EU.
The facts obviously sent ripples around the world. There's a
I know they did. Yeah.
famous article by a French jurist, Londres rit et Paris pleure. You know, London's laughing and Paris is crying.
Yeah.
Because of the international consequences. But so that was the background, and essentially the argument was that the duty of the with greatest respect, the rather one-sided duty of sincere cooperation, which the CJEU has held, which appears to say that even if the EU itself has not cooperated at all, you still have to cooperate. So that's the EU law. Meant that the United Kingdom would have to breach its clear ICSID obligations by staying an award pending the Commission's investigation on facts which were pretty striking, putting it mildly. And when we got to the Supreme Court, there was an analysis of two things. And this afternoon, I'm not going to deal with the EU points this afternoon, but it would be helpful, I think, the court just to look at the court's treatment of the ICSID convention that starts at paragraph 59 at 1682. The court's probably read this judgment already, but I just may be helpful just to highlight a couple of points. The court starts at paragraph 59 with 154 state parties to the convention, and the EU is not a party to the ICSID convention, and then identifies the relevant provisions, and then deals with the Act, paragraph 63, sets out the provisions, and the rules at 64, and then the argument begins at 67, and at 68 the court identifies the provisions of the Act must be interpreted in the context of the ICSID Convention. It should be presumed that Parliament, in enacting that legislation, intended that it should conform with the United Kingdom's treaty obligations. It is a notable feature of the scheme of the ICSID Convention that once the authenticity of an award is established, a domestic court before which recognition is sought may not re-examine the award on its merits. Similarly, a domestic court may not refuse to enforce an authenticated ICSID award on grounds of national or international public policy. In this respect, it differs significantly from the New York Convention. And then summary from Professor Schroyer from the section of the previous edition, the one we were looking at. And then 69, contracting states may not refuse recognition or enforcement of an award on grounds covered by the challenge provisions in the Convention. And we know that those include jurisdiction. That's an important point because it ties in with the Article 41 tribunal judge of its own competence and the effect of the award as a result being binding and so forth. There's the possibility of an unidentified arguable defence left outstanding over the page 1686, but it can't be anything that is in Article 50 to 52. So we're not concerned with that, and it's only a possibility that's left there by the Supreme Court. And then 70, the principle that arbitration awards under the ICSID Convention should be enforceable in the courts of all contracting states and with the same status as a final judgment of the local courts in those states, as eventually set out in Article 54, was a feature from an early stage. Mr. Aaron Broche, General Counsel World Bank, chaired the meetings that occurred as part of the Convention's drafting. Explained delegates that by virtue of this formula, contracting states are entitled to apply their local law of sovereign state immunity with regard to the enforcement of awards. And go down a couple of lines. Accordingly, it was made clear that Article 54.1 had the substantive effect of introducing some degree of principle of equivalence between a convention award and a local final judgment as regards the possibility of applying defences in respect of enforcement. And can I just ask the court just to underline the word defences there? Because just to be fair to Mr. Justice Fraser, my learned friend took a point yesterday that he'd referred to state immunity as a defence. And it's a tiny bit unfair because at the hearing, we were compendiously discussing, as the Supreme Court had in Micula, all possible objections to enforcement of awards and using the word as used there by the court defences in a general sense. So I just want to be fair to the learned judge below that he was under no illusions. We canvassed over 4 days all state immunity authorities. So he was under no illusions about the importance of state immunity and so forth. He was not using the word defence in a procedurally precise sense in the judgment.
State immunity wasn't raised in Micula.
State immunity wasn't raised in Micula, wasn't raised by the judge at first instance, it wasn't raised by the Court of Appeal, and it wasn't raised by the Supreme Court. And given it was a head-on-head clash, that would have been the easiest answer.
But it would have had to come early, would it?
It would have had to come
Once you
early.
had submitted, that was that.
I think that's fair. I mean,
It's true.
so that's fair. But it's definitely, I mean, the idea that Mrs. Justice Cockrell did not think that there was clearly no immunity here when she made the registration order seems to me, with respect, fanciful. Or every commercial court judge charged with making these registration orders is extremely experienced, knows the convention and the act, and is well aware of the fact that it jumps the dike and you register it. And that's been implicit in court practice throughout. So, but your lordship's right. It would have, just to be fair on Micula, I think the Supreme Court might have had some difficulty reviving a sovereign immunity point, perhaps. And then the 71, para 71 on 1686 is the report, Mr. Broch's report, certain comments dealt with the effect of what was then draft section 15, which became Article 54, on existing law with respect to sovereign immunity. Mr. Broch explained that the drafters had no intention to change that law by providing that the award could be enforced as if it were a final judgment of a local court. Section 15 implicitly imported the limitation on enforcement in which in most countries existed with respect to enforcement of court decisions against sovereigns. However, this point might be made explicit in order to allay the fears expressed by several delegations. That's the quote. And the court refers to it being made completely clear to allay concerns at the bottom of that paragraph. And then 72 deals with its introduction for the avoidance of doubt. And we can see over the page at 1687, and I'll try and find a natural break in the next couple of minutes, but 1687, a right-hand margin about 4 lines up on the right, as Professor Schroer points out in his commentary on Article 54, persons seeking to enforce arbitration awards made pursuant to the Convention will tend to choose to do so in those jurisdictions which have least generous rules of state immunity for the protection of assets of other contracting states. And then 73, the fact that the specific qualification of the obligation to enforce an award like a final judgment relating to state immunity was expressly dealt with in Article 55 for the avoidance of doubt indicates that Article 54.1 was itself understood to have the effect of allowing the possibility of certain other defences to enforcement if national law recognised them in respect to final judgments of local courts. The travaux préparatoires then set out extensively, and if you come halfway down the left-hand margin between E and F, you see 312. It says there, but he also resisted a proposal by the Austrian representative to delete the words, which in what became Article 54.1, requiring an award to be enforced as if it were a final judgment of local court, so as to make the obligation in that provision an unqualified one, since the Austrian representative noted there were several possibilities for annulling judgments even after they'd been declared final. he then continues at letter G about the possibility of a judgment obtained by fraud being considered, and at H in the same way on the right hand side, if a final judgment was open, some extraordinary remedy in the case of fraud or similar occurrence, that would be true for the award as well. So there's a very exceptional possible residual category other than those in 50 and 52, which might exist, is where the Supreme Court ends up. And so they reach that conclusion, and this is the end of this piece for this afternoon. And paragraph 78 on 1688 at the bottom of the page. However, in the light of wording of 54.1 and 55 in the travaux reviewed above, it's arguable there's scope for some additional defences against enforcement in certain exceptional or extraordinary circumstances which are not defined if national law recognises them in respect to final judgments of national courts, and they do not directly overlap with those grounds of challenge to an award which are specifically allocated to convention organs under Article 50 to 52 of the Convention. So is that a convenient
That's a
spot?
pretty clear statement that you can't rerun the defences that you ran before the
Or
tribunal or in the annulment proceedings.
yeah, and indeed, you can't rerun the ones you could have run that fall within those articles, even if you didn't take them. It's the defences that are allocated to the convention organs.
Yes.
So it's even
Yes.
stronger than the New York Convention example, where you've got the Section 73 thing of did you take it, did you not? You know, here it's 50 to 52 convention organs. If you want to run it, you have to run it there. If you
There's
don't,
also an abusive process stroke.
there's a subsidiary
point there.
estoppel point
Abusive
there.
process point. There.
Yes. I mean, just on the estoppel point to foreshadow it, I mean, I think my learned friend, Mr. Harris, takes the sort of formal estoppel point. And I think the way we would respectfully frame it, and there's no difference of result, is that it's really a statutory, it's like a statutory estoppel by giving a statutory conclusion to what happens when you produce an authentic award.
Yeah.
There's no room for anyone to say, oh no, and then I go, but you're estopped. You don't even get to the oh no bit. It's like Parliament says, there it is.
Is that a convenient moment? So we're doing pretty well.
We're doing pretty well.
10:30 tomorrow morning.
I'm most critical.
All right, in favour?